My name is Bush Nielsen. This is the third in a series of videos in which I discuss issues about closing protection letters and also the rules that lenders are using in order to certify a title agent to be on its panel or list of approved closing agents. In this video, what I want to talk about is the types of claims that title insurers pay on closing protection letters. The type of CPL claim that most people think about is when a title agent steals money from the escrow account. I've handled a number of claims of that type, and let me just describe how those claims are actually handled. There are a number of misconceptions that people have about how those claims are handled. Let me give you kind of a standard set of facts. Say a title agent escrow account has a balance each day of about $2 million. And of course, each day that's different money that's in and out of that account. And then let's say on a Friday afternoon, the owner of the title agency decides that he's going to send a wire to an account that he controls that is really a fake account that is in his name but not in his name. And he's going to send the wire for $1 million, and then he immediately leaves town. By the way, this hardly ever happens, the leaves town part. The title agent owner often just takes money in small pieces and then stays in town and is still sitting at his desk when he's arrested by the police. But let's say this owner does the smart thing, if you want to call any kind of theft smart. He wires the $1 million to some account, he leaves town. Let's also say that the title company did 10 closings between Wednesday and Friday of that week. And it issued about $3 million in wires and checks to the people who were involved in that closing. Let's also assume that the first $2 million of those checks and wires were paid or honored by the bank that held the escrow account. And those checks were, or wires were received by sellers, real estate brokers, lenders who were receiving payoffs. So that would leave the last $1 million of checks and wires that would not be honored or that would be disapproved by the bank. Now, the first thing to notice is that it is impossible to say whose money was stolen by the owner of the title agency. He took $1 million, but really the way it sorts itself out is that the last $1 million of money which people ask to receive from the escrow account is the $1 million that was stolen, because everyone who submitted their check earlier had their checks honored. The last $1 million is typically in checks. Often, these are checks that were issued 2 or 3 or 4 weeks before the theft. So this person, if he had delivered his check for payment immediately, would have been paid. Now, let's say that of this last $1 million of checks that were not paid, some that had been issued to lenders on loan payoffs, some had been issued to sellers for the proceeds of their sale of their homes, and some had been issued to real estate brokers for commissions. Also, let's say that all of the lenders who were involved in the closings for this title agent had received closing protection letters, but sellers and borrowers did not receive those letters or could not because there was no law permitting that. Here's how a title insurer will look at it. The title insurer will almost always make good on loan payoffs that were dishonored by the bank. There are 2 reasons for that. First, the title insurer has liability typically on the new title insurance policy that it will have to issue to the people in the transaction. That means that the lien has to be paid off so that the lien is removed from the property. Also, of course, the title insurer has issued a closing protection letter to the new lender. So it really has dual liability under the policy and the CPL. Loan payoffs are typically made then. The title insurer will almost always not make good on checks that have been issued to sellers for their equity in their homes. This is because sellers don't have liens on the property, and they don't have the protection of closing protection letters. Title insurers will never pay real estate brokers their commissions and those checks that were dishonored. Also, here's another common misconception. The title insurer never figures out how much money was stolen by the owner of the title agency, called the whole, and then simply issue a check or put money into the account in order to fill the hole. That is not how the title insurer handles these claims. It differentiates the claims based on liability. So some people who did not get their money out of the $1 million that were stolen by the title agency owner will simply never receive that money from the agency owner or anybody else. So as you can see out of that list of people that I just described, sellers in particular are victims, and they are completely innocent in the situation, and they have lost the equity in their homes, which is something that is not recoverable by them. This is a huge loss to them. This also means that they cannot close on the purchase of a home, which is typically waiting to close on the day that they receive those checks. Also, if the title insurer has not issued closing protection letters on behalf of this title agent, the title insurer never pays any of the people whose money is stolen by the title agent. It's another common misconception that a title insurer will simply make good on all of those checks out of a sense of business honor because its agent stole the money. Well, in fact, that title agent was also the closer for the lender, and it was the lender's agent who stole the closing money. This is not, when a title agent performs a loan closing, it is not acting as the agent of the title insurer. It's acting as the agent of the lender. So it's the lender that will sometimes sense business honor and that will sometimes make good on checks that its loan closer stole. But that doesn't happen very often either. I'm also often asked if the title insurer pays claims on CPLs when a title agent hasn't stolen any money. And the answer is yes, sometimes. In several recent cases, the FDIC has convinced federal courts that the insurer has to pay money under the CPL for losses that were caused by the borrower's loan fraud. In a very recent Florida case, the court said that the agent was guilty of dishonesty in the handling of documents and money for one simple reason, because the agent permitted the borrower to come to closing when the borrower did not bring the down payment with the borrower. A third party supplied the down payment. That was the only thing that the title agent knew or did at closing. Now the borrower was perpetrating a fraud on the lender. The court found that the title insurer, based on the CPL, was obligated to pay the FDIC the entire amount of the loan principal and interest because of this supposed dishonesty of the title agent loan closer. So that's a significant risk that a title insurer had that had nothing to do with the theft of money. The Florida case, by the way, relied entirely on a 2014 decision out of the state of Michigan, which made the same ruling. Now, the FDIC, after this Michigan case, has become emboldened and has filed scores of lawsuits all over the country in which it is trying to receive millions and millions of dollars from title insurers based on this supposed dishonesty of the loan closer who has not stolen any money. These cases really have to do with fraudulent appraisals and loan fraud perpetrated by borrowers. The problem is that the FDIC keeps winning these cases in federal court. Well, that covers what I know about the major claims issues on closing protection letters that have come up recently. Please watch the rest of these videos for more information. Thank you.